My name's Luiey Haddad with Equity Legal. I wanted to get started with you guys today and talk about our session called Don't Flip Out. Essentially, it's a quick but understandable guide, legal guide, and common sense guide to the issues you want to address when you are dealing with a flip transaction, in a home improvement transaction of a potentially distressed property, otherwise an improved property that you're later either going to sell yourself or sell on behalf of a client. And so I wanted to talk about the different pitfalls regarding the pre-purchase of the actual property itself, the issues and nuances regarding title, zoning, and the business aspects. Then move on to the next section of discussing the actual purchase and sale involving the contractor, involving disclosures, involving the structure and how you actually handle the transaction as a whole. So I'm here to answer any questions as well. We're live streaming, so you're able to fully go ahead and message during this, and I'll try to answer as best as possible. But just be aware that there's so many different factors and variations in these different transactions that there's no way I can address all of them, but I'm going to try to give you a nice broad stroke so you have a 30,000 foot bird's eye view of overall what you need to consider when addressing a property that's going to be flipped. And so I wanted to start off by talking about the pre-purchase issues we have with buying a property. A lot of times, you're seeing on TV, with all the flipping shows and all these, a lot of agents also, are flipping and so are their sellers. And so you're seeing a lot of, the nice bells and whistles, the nice, the things that, look good on TV, but there's a lot of groundwork that's done before anybody purchases these sales or these homes, or at least there should be. And these apply to residential, by the way. We're not talking about any commercial properties or any improvements on those or any things of that nature. But just specifically with residential properties, the issues that go behind the scenes that you need to kind of resolve prior to ever purchasing that property, whether that be your client purchasing the property or you purchasing a property for later resale. So the initial thing I wanted to get into were the business issues. And again, as an attorney, I always start with worst case scenario, what's going to happen? And let's make sure we don't see that. Let's make sure we set ourselves up for success versus a potential liability down the road, potentially, ignoring some issues and hopefully it won't come up later. But sometimes it just seems to rear its ugly head. And if you start getting this practice of doing this thing over and over again, you're going to be well ahead of the curve with respect to liability issues, business issues, and overall profitability at the end of the day, because that's really the name of the game. And so if you're running around defending lawsuits and settling cases and spending your time and money doing that, you're not out there finding your next property. You're not out there finding your next client. You're not out there selling your next transaction. So these are all things that are meant to allow you to run your business more smoothly, properly, and without the issues that come up and ignoring these potential pitfalls. So starting out with the business issues, a lot of times when we're doing these flips, you're either investing yourself, your client's investing, or you have investors or a group of investors that are funding the project either primarily through a hard money loan, through a personal loan, or your own funds, or you have a group conglomerate that are pooling their funds together and buying either multiple properties or single properties. But that doesn't matter. Any one of those issues are going to I would recommend setting up an LLC or a business entity that actually handles the transaction and the funds, keeping your personal assets and funds separate from the business and investment assets and funds. And those do two things. Number one, it protects you from liability in the transaction moving forward to a certain degree, and it protects your investors' funds as well. But what it also does, especially if there's a group, it protects you each from each other's potential issues that might arise. So if there's an issue that arose with investor A of the group and investor B has nothing to do with that issue, this investment structure of an LLC or a corporation or some business entity to run the investment through will shield you from their potential personal liabilities. Now, if you had a partnership and you did this, it would not protect you from their personal liabilities. You would be deemed severally liable, potentially, along with them. So this protects you, it protects your investor, and it protects the group of investors from each other and their own personal liabilities as well. So if you don't do that, you're really opening yourself up to any number of issues, from everything from bankruptcy to potential unrelated lawsuits to related lawsuits that you had no idea was going on. But these corporate documents will also, if there is an issue that arises, outline how that issue is resolved, and will likely keep you from going into a costly litigated matter in court. So setting up the business to protect yourself as an investor, to protect your client as investors, and to protect groups of investors from each other is really the ideal path to move forward. So once you have that set up, once you have your investors lined up, once you are starting to, you either have a property in mind or you're starting to look at properties, the next thing you really want to look at is title issues. And the reason why I say this is, you go buy a property and you're purchasing it from the seller. You don't think there's any issues whatsoever. But then it turns out that, there's an issue with a mortgage restriction, or there's an issue with a deed of trust that might have been transferred a couple times and maybe not done appropriately, and that potentially opens you up to what's called a quiet title action from potentially a prior owner, or even something as simple as having a different name. Some people use shorter names like John Lewis. Some people say Jonathan Lewis Jr. Some people are a senior. And so those imperfections in title could potentially come back and keep you from closing your transaction. And while they'll probably be able to be worked out potentially through escrow, as we all know, and as anybody that's working with an investment property or flip property, time is money. So an escrow that's extended 60, 90 days out to resolve these issues. An escrow, you're dealing with holding costs, you're dealing with interest, you're dealing with investors that are breathing down your throat. You're dealing with a seller that thought his home was about to be sold, but now it's going to be held up, and they're bearing the burden of all these things. And so making sure that title is free and clear, and there are no deficiencies within title is very important when you look into it. Generally, you can do a title search or title pull, and with Big Block, obviously, they have the luxury of working with Ryan Lipsy and his team with Ticor, and I'm sure they'll be able to give you a property summary profile if you don't have direct access to it, to allow you to ascertain the overall status of the title at the end of the day. And if you have questions, I'm sure Ryan and his team at Ticor can also help you out with that, and answer title questions and questions that are related to those particular issues. But looking into those is very important. And at the very least, to give you just a peace of mind that everything's fine with this moving forward, we're not going to have an issue. So that's the next thing I would look at. The third thing I would look at, especially if you're looking to improve, the third thing would be zoning and permitting issues. And the reason why I say that is specifically because I run into zoning and permitting issues almost more than any other issue with respect to a real estate transaction, and things that stem from that, the disclosures, the information you provide, even the MLS posting really has to take into account that zoning and permitting issues, and how you're going to present that to the outside world, to the potential buyer, to your seller, to your investors. And so at the end of the day, this really comes up a lot of times with expansions, adding square footage, or if you're building ADUs, because right now, obviously, the city has made lax and expanded the ability to build ADUs on certain properties. And why that may be the case, there are also restrictions on those properties potentially. For instance, if I wanted to build an ADU in this beautiful, let's just call it a 9,000 square foot backyard, and it's beautiful. I wanted to build an ADU back there. It doesn't look like there's any problems. It's enormous size. You're not going to have any problems, just plotting in a nice little 1-bedroom, 1-bath ADU in the back. You anticipate collecting rental income from that. You anticipate the value of your property going up. You're remodeling it. Next thing you know, you find out there's an easement issue. Now there's an easement that could be running through the backyard for all number of purposes, for sewage, for drainage, for access purposes, for utilities potentially, for any number of different things that would require keep you from building in a certain area. And if that's the area you thought you were going to be putting an ADU, that's really going to throw off your plans and potentially could kill your plans. Also, a lot of times people are buying a property or multiple properties and they want to do either a lot split or a lot adjustment and a property line adjustment. And if you're doing that, you really, really need to go in and do your due diligence regarding the zoning, because it's not as simple as saying, oh, I want to connect, my property with the vacant lot behind it, buy it both, and now we have this, enormous property that we could develop potentially to multifamily or even just put multiple single-family homes on these two adjoining lots. But then you might have zoning issues, and again, reiterating, the easement issues, or even where the sewer line connects. Does it run to both? Is it allowed to do both? So you have these issues with respect to zoning that you really want to hammer out before you are fully contemplating the full analysis of your transaction, especially if it's going to be looking into expanding, adding square footage, or putting in an ADU. The other issue, and that's kind of more of the zoning side, but on the permitting side, I run into this all the time: unpermitted garages, unpermitted room additions, unpermitted ADUs for that matter. If an investor is going to buy a property and they believe it's either permitted or even the quote unquote the all permits unknown blanket statement, you have that and you think you're fine, but the investor doesn't want this house for themselves. They want to go rent it out. If you have an unpermitted ADU or room addition, you cannot rent that for any dollar. If you rent that out for $1, that person who's renting it out to you and the investor who you sold the property to can come back after you for all those funds and then some, and potentially rescission of the contract, which means they want all their money back and you take the house back that has a bunch of worthless additions to it. So the permits are very important if you're going to be flipping, especially if you're going to be doing it yourself. Obviously, if your seller's doing it, you're not responsible for their permitting disclosures and research. However, you should be advising them in writing that they need to go seek their permit history and make sure that the things that they're doing is allowable. Because if not, that could come back to get you. And I've seen it many, many times. And people say, hey, it's not going to happen to me. Maybe not. But when it does, it's a catastrophe. It's a lot of money. And if you sold the property and listed the property or a part of the transaction, then you're really looking into some really high dollar figure jeopardy that you want to try to avoid. So, addressing those issues are really important. I also had a case just recently come up where, an investor purchased the property, a beautiful property in a nice neighborhood, but somewhere down the line, the developer didn't put that property on the same line and sewer line as the rest of the development in the area for some reason in the past, whether that particular owner of that lot opted out of it or so on and so forth, that wasn't there. So when somebody else bought it, obviously without the disclosures, and they learned that they would have to pay upwards of $100,000 just to connect their property to the sewer line. Now this investment property went from a great bargain to a money hole. And so at the end of the day, those are the kind of things that you want to look at, especially with vacant lots. If you want to develop those, if there's already existing residents on there, then that's not something you need to worry about as much as the easements and the permitting issues. So obviously, I can talk about this forever. And if you have questions regarding those, you can reach out to our office directly. But those are issues that are going to come up a lot, especially in San Diego, as less and less land is available, and you're going to have to be recycling properties that are already there, or you're going out further to East County or North County where the lots are not developed as much, and you need access to your property either through a private road, or you don't know where your fence line is, and you don't know, where your neighbor's property starts and where stops and where yours begins. Those are the kind of things you really want to look into, especially if you're going out to more of the rural areas that are being newly developed. In addition to, obviously the areas that are already developed with established lot lines, and make sure that that's what's reflected in title. So back to the title issue. So these all kind of go with each other, and you can't do one without the other. But as you can see, just short issues I'm talking to you about, they could be varied and many, and they can be multiple on a single property. So those are the kind of things you really want to look into as well. So those are generally the pre-purchase issues that you want to address. You address those. You address permitting and zoning. You address your investments, and make sure that you're separated from those, so you have a delineating line, keeping your accounting appropriate. That'll protect you from any potential fraud and financial issue cases. And then obviously making sure that your zoning and your title issues are all cleared up. Title's clear, you're able to get it. Another issue I wanted to bring up on title that came up recently was a lot of people are buying properties in foreclosure sales. You have to know there in certain properties there are rights of redemption, and we can get into, I can talk about that at a whole nother transaction, but training. But with the right of redemption on foreclosures, it gives the buyer the ability to come back 60 to even a year down the line, come back and get their property back. And so you want to make sure that whatever you're doing, that potential homeowner has their rights either extinguished or satisfied by the time you purchase the property. And then finally, obviously, and this is something we're dealing with a lot these days because of COVID, because of the moratorium on evictions, is you have a tenant in the property. Sometimes they'll leave a little cash for keys, here's some money, they'll go. Sometimes they have nowhere to go. Some of them have no jobs now. Some of them are dealing with having to, try to find a new place during the COVID years or the COVID months, if not, hopefully not years, but COVID months. And so in doing so, if you are trying to buy that property as an investment property, there's a renter in there, especially if the renter's not paying. It's one thing if they're paying, and you could say, well, we can keep them in there, extend the lease, and then that's fine. I still got money coming in. But if they're not paying, now you have, a liability in there, and you don't know when you can resell that property. And so knowing and thinking ahead on those issues, which is what a lot of the agents do, to reach out to our office to address those issues, either pre-transaction or during the transaction. And many times we resolve them, but many times it takes time. And so you need to equate that into your calculus in your transaction and the profits at the end of the day, because time is money with flips. So assuming you've addressed those concerns, and you put those to rest, and you can, go to bed at night going, okay, this property is a good transaction to move forward on. Let's buy it. So now you bought the property, or your investors have bought the property, and you are starting to begin your flip. The legal issues there are resolved. Then you move to the pragmatic issues of how are we going to do this and how much is it going to cost? In order to really evaluate that, obviously, you need to have experience in the market. You need to have experience in valuing all this, but you also need to have a darn good contractor. You can't do this without a great contractor. I see shortcuts all the time, and they, more often than not, this isn't even like a small percentage, but more often than not, some issue comes up when you have a poor contractor. That's why it's very important you have a licensed and preferably bonded contractor that you can hold accountable should something go sideways. And to make sure that the quality of work is at the highest level possible. I mean, if you want to go to the contractor state licensing board, if there's an issue, you have that ability. You don't have to go straight to court and spend all this money, but they have to be licensed. They have to be a contractor that you can hold, accountable via at the very least an administrative action. So those are things that are very important. I know a lot of people want to say, hey, it's a flip. We're not promising permitting. We're not promising, zoning or anything like that. You can say that all you want, but the purchaser is going to want that. And whether you promised it or not, not being able to, put your work at the level that, you're promising or at the level that someone's expecting, then, you're going to have issues. So key is to get a contractor that you trust. And a lot of times, in speaking to agents and other developers and other flippers, they tell me, hey, listen, the best thing to do is get a contractor that either you've worked with before and you know their work, or have worked with somebody else and have worked with them with that referral. Not just, hey, I know a contractor, I never worked with them before, but I heard they're good. Best person to get it from is from another agent that's worked with that contractor and can vouch for their work and say, hey, look at these examples here. And you do want to go look at some examples from this contractor, especially if they're doing this kind of business, often in multiple flips. These contractors, a lot of times, they're very good, but sometimes, they'll have an issue, that arises on a certain transaction. So if you can compare most of their work and, you can feel comfortable with that, then that's, something that you can, again, rest easy that you have somebody that's a professional doing the work for you. Obviously, you still need to be on top of them. Either your investors, your sellers, or somebody, a project manager, needs to be on top of contractors. A lot of times they get even though their quality, they split themselves a little bit too thin because they're trying to do too many jobs at once. So these are all the factors that you want to evaluate when you're picking a contractor. And once you've picked a contractor and you like them, or you have a couple different bids from different contractors, and you want to decide on one, the next key, and this is really key, and I've seen this so many times, that these are handshake deals with these contractors. I'm going to do this for this amount. I won't go over that amount, and that's what I'm going to do. And it's all verbal. I've seen it way too many times, and it's kind of disappointing considering that real estate agents are professionals. They take the contract courses. They know that, a writing is more important than something that's, it's stronger than something that's verbal. Yet for some reason, they continue, and a lot of agents continue to do these things on handshake deals. And that's a no-no, and for many reasons. Number one, it's not legal. Any home improvement contract over $500 is required to be in writing. It's required to describe in detail the process of the work, how it will be performed, i.e. the size, the color of the cabinets, the finishes, the work, the materials that will be provided, the manufacturer of appliances, anything that's going to be installed with them. Those things are required to be in the contract. Additionally, there needs to be a written payment schedule. Down payments cannot be any more than 10% or $1,000, whichever is more, of the contract price. And so there needs to be a payment schedule that's in there, so you're able to hold them accountable. You're not giving them all the money up front, and then they leave you stranded high and dry with a half-finished house and demanding payment, or else a mechanic's lien. So those are the kind of things that if you have a contract, you have the terms under which they're required to move forward or not, and you are clear as to what the scope of their work is going to be. It also needs to be written. If any necessary permits need to be obtained, that needs to be in the contract as well. Specifically, if you're remodeling swimming pools, even, that has an additional requirement that the actual pool has to, in the contract, have a diagram and an outline as to what it's going to be like, the shape and the size. And that's actually a requirement from the California State Contractors Licensing Board. So those things need to be in there, but I'll tell you why it's beneficial to be in there. You might look at it like, oh, it's a headache. The contractor doesn't want to take this job at this amount already, and so on and so forth. If that's the case, let them walk. You're going to lose more money mediating and litigating an issue with the work product than you are saving yourself $1,000 to $10,000 because the contractors are cutting a corner here and there. And additionally, the contractor needs to identify who's doing the work, the subs, the contractor themselves. They need to provide their license number. They need to provide the information that you will need to hold them accountable should something not happen. So, and then finally, warranties. Sometimes they're not required to be in the contract, but they're required to be in writing if you're going to get one. And so never do a verbal warranty either. Just like anything else, so you want to get it in writing. And so if there's a warranty on the work, a warranty on the labor, a warranty on the materials, a warranty on the appliances, you want to make sure you get all of that stuff in writing so that you can, address those should they come up later. Two of the biggest areas I always see coming up in mediations or litigation are the bathroom and the kitchen. A lot of times because of the water and the piping and the rerouting and things of that nature, but also because of the intricate tile work, the level of detail, and water. Water always, has a way of getting through where it's not sealed. And so if you don't do the work to the highest standard, those things are going to show up in the bathroom and in the kitchen. And so if you're remodeling those things, this stuff is extra important, if not, mandatory. So, and the reason why a lot of these issues are not only beneficial to you, but also, should be required, is required under law, but also beneficial to your seller. Because if you are not selling the property yourself, or even if you are, you want to know what work was done. If a contractor's in there just doing the work and just saying, I did this, this, and this, and next thing you know, he rerouted a gas line the wrong way, or he didn't repipe the plumbing the way he said he did, or, there's certain quality of work that he said, oh, I put that in there and I drywalled the bathroom when actually he used green board, or I didn't do the hot mop, when as he said he did. So there's a lot of, details within that he could say he did, but then you get in there and they did something different. So that holds them accountable, but it also allows you to disclose things properly. That's the other thing that always comes up, not just the workmanship of the property, but the disclosures and what you tell them is going on there. Failure to disclose issues, as amounts to a breach of contract and amounts to a lot of liability, triggering your errors and omission policy, and triggering big blocks need to defend any potential case, whether that be through mediation, arbitration, or litigation. And so not knowing what your contractor did, not having it in writing to go refer it to, and not knowing exactly the time and cost to address those disclosures, you're going to be in the dark on a lot of things, and you could get hit with an issue that you didn't even know happened. And so it's not always your fault, and it's not fair, but it is exactly, the type of thing that comes back to bite both the agent and the brokerage at the end of the day. And so some issues with disclosures that I've run into in mediations, and these things I think will be helpful to you overall. Number one, just saying that there's no permits is not going to get you very far in litigation or mediation. Just saying, hey, permits unknown doesn't get you very far, especially considering if you do work around it and you have a licensed contractor that did work in an area that they had an idea of knowing was unpermitted, or, there's no way you couldn't have known, which is a lot of arguments on the plaintiff side. How could you not have known this? How could you not have known there was mold back there? How could you not have known this bedroom was an addition that wasn't permitted? That threshold is enough to get you into that mediation, into litigation, and cost you thousands, tens of thousands, sometimes hundreds of thousands of dollars. So not knowing what's permitted is important, and how you disclose it is important. And then additionally, if you are stating that, building was up to code, it better be up to code, because if one thing in that entire flip was not up to code, now you've basically got yourself caught in either a lie or misrepresentation. Even if you didn't know it yourself, saying that it's up to code is going to be something that is a material representation to the buyer or the outside world that this is in fact, to code, when it might not be. So you want to avoid saying to code if at all possible. And if you don't know, again, you're not the contractor. You hope they did it to code, but you don't know 100% if they did it to code or not. But that goes back to the reputation of the contractor and your reliance on them. Also saying that not only is it up to code, but done in a work-like fashion, a work-like manner. Again, you could say that, but you don't know what's behind those walls. You don't know, again, if they used certain materials that are outdated or ineffectual or otherwise, would not have been done at the standards that, a professional work like bonded licensed contractor would do. And if that's the case and it comes out later, then even though you did not personally know that, you did not personally do the work, you're relying on your contractor, the seller is going to hold you accountable as their broker, and the buyer is going to hold you accountable as the person who helped the seller disclose this information to them. And if you are the seller, double whammy, you get hit as the investor and seller, and you get hit as the broker. And E&O does not cover you as the seller, so that's going to be out-of-pocket cost the entire way. E&O will cover you as the broker and only those claims. So having that contract is so important for holding your contractor accountable, but also knowing what work was done and knowing what to disclose on a flip. I mean, if you're flipping a 100-year-old house in the middle of Hillcrest, you're not going to know a lot of things. And so you want to stay away from having those material affirmative representations. You want to, obviously portray the property as it is, but you don't want to, use puffery on the MLS, on the disclosures. If you believe, this is an immaculate property that's done at the highest level possible. We don't know if permits were not pulled. We're unsure of, permitting issues. However, the work was done to code. They're kind of contradictory if you say something like that, because if it was done to code and not permitted, potentially it'd be required to be permitted in order to be to code. So unless you are the contractor or you have the knowledge of a contractor, you want to stay clear from using comments like that. And then, through your brokerage, you have issues if you are the agent and the seller. Now, if you are the agent, you can be held accountable for your disclosures and your representation to your client or clients. If you are the agent and the seller, two things are true. Number one, you have to abide by the terms of the E&O policy and policy manual of Big Block in order to sell your own flip. Now, two things would be required. Multiple things are required, but at least two things I can tell you right now. And these are the things you want to, address with your broker before you do these things. But number one, you're going to need a personal property addendum. And that's a form attesting to the fact that this is your personal property and that, you are selling it on your own behalf. And that's something that you would indemnify, certain parties as a result of any issues. And so that's something that needs to be signed prior to any transaction in which you are both the listing agent and the seller. Second issue is you cannot double end a transaction where you are the listing agent and the seller. You can't also be the buyer's agent in those things. So that is a no-no. That is something that could potentially have you lose your license and potentially have you lose your good standing at Big Block. So those are two very, very important things if you are both the listing agent and the seller. Now, if you're not the seller, you could potentially double end them in that manner. So, but again, if you have a team member that's listing it and then you're the seller, that's really not going to have that effect that you think it's going to have because you're too closely intertwined. It's a team member. You need to have another agent that's not affiliated with you whatsoever and doesn't have, that kind of financial interest in your group that you have in particular with that transaction. So just know those nuances between if you're the listing agent and seller versus if you're just the listing agent versus if you kind of have, a teammate doing the transaction while you're still the seller or investor, or you're a part of the group that's investing. That's still, again, you have personal interest in it. And so those things need to be addressed with your broker prior to any of these transactions. And then it goes full circle back to the very beginning as to having, that separate entity as an investment vehicle that's going to protect you and separate you from being the listing agent and the seller or a group of, an interest within the group of investors. And so, to conclude, going through, I know there's a lot of information, but going through those processes are very important. So, again, in summation, you want to address the pre-issue sales, the pre-purchase issues with respect to forming the business entity, making sure your title's free and clear, making sure whatever you want to do on the project is allowable, and that there's no current issues with the zoning or permitting issues with your property. Then upon purchasing it, you want to vet your contractor. Make sure that they are somebody that's trustworthy, that's licensed, and most preferably bonded, and make sure you have that home improvement contract in writing. Any change orders must also be in writing. The last thing you want to do is, if you want to have a professional long-term career in real estate, which I know many of you do, you can't do things off the back of a napkin, and you can't do things, on a handshake and verbal deal. Times are changing. Everything has to be in writing. The old way of doing business is not going to fly, and in fact will open you up to so much liability that it might take you out of the business altogether. And that's the last thing we want for you. After making sure you have a proper contractor in the contract, you want to make sure the job is done right, and that when it's concluded, that you have the disclosures that reflect exactly what was in that contract. And if for some reason it's not, you're going to be able to hold the contractor accountable. And then finally, obviously, make sure that you are compliant with all the errors and omissions and requirements, and your own brokerage's policies with respect to flipping your own property or representing a buyer that is somehow either flipping a property or has a particular interest that aligns with yours within that particular transaction. So if you have any questions, I know there's a lot of information, but if you have any questions regarding a specific transaction, you have any questions regarding any of the information I've brought up, any clarification, any further deeper dive with respect to your factual scenario, feel free to reach out to our office, 619-663-4533, 619-663-4533, or contact your broker, Kim, and she'll be able to get you in contact with us if you have any legal issues that she can't address from the outset, because she's also an attorney and able to handle some of these initial questions. But a lot of these issues with respect to the deep dives into the factional scenarios with our background in litigation and the hundreds of mediations that we've done, we see a lot of these things, and we're able to kind of give you that extra little bit of guidance that you're going to need to make sure you have a successful transaction, and at the end of the day, a successful career with Big Block and with your life. So I wish you guys the best. If you need anything, give us a call, and we'll be here for you moving forward. Thanks, guys. Take care.